You should be very proud that you have made it to the national competition. It says a lot about how hard you have worked during these 2 semesters and how well you have mastered the subject matter that we're going to be discussing. You should know who your judges are. So I am Edward Volpe. I'm an attorney from Denver, Colorado, and my fellow judges are.
Hi students, my name is Caitlin Johnston and I am an attorney in New York City. I am also a We the People alum. I did it in high school when I was growing up in Indiana, but I never made it to nationals. So congratulations on that. What an accomplishment. And I am looking forward to our discussion today.
Hello, Oregon. I'm Ed Murphy. I'm a Superior Court judge in Tacoma, Washington. And congratulations for making it to nationals. I look forward to hearing your presentation.
Now, if the students would introduce themselves in the order in which they will be presenting.
Hello, judges. We are Unit 5, and we'll be discussing the Bill of Rights. We would like to thank you all for being here today. We'd also like to thank our coaches, Laura Queistinen and Bree Kalk, our teacher, Sadie Adams, and our mentor, Lana Paris. My name is Sadie.
My name is Ben.
My name is Lauren.
My name is Madison.
And my name is Irji, and we are now ready for your questions. Thank you.
Very good. The question for you today, quite obviously, is question 2, and I will read it to you. A Bill of Rights is what the people are entitled to against every government on earth, general or particular, and what no just government should refuse or rest on inference. Do you agree or disagree with Thomas Jefferson? What are the advantages and disadvantages of a national Bill of Rights as compared to state bills of rights? What are the differences between positive and negative rights, and which are more important to the preservation of liberty? You may begin.
I respectfully disagree with Thomas Jefferson. When power rests with the people, a Bill of Rights is unnecessary. As Alexander Hamilton argued in Federalist 84, the people surrender nothing, and as they retain everything, they have no need of particular reservations. Historically, bills of rights such as the Magna Carta and the Petition of Rights have failed to adequately protect people from government abuses.
Even our own Bill of Rights has its limitations. It took nearly 130 years after the ratification of the U.S. Bill of Rights and over 50 years after the ratification of the 14th Amendment for the Bill of Rights to begin to be effectively implemented by the courts. What protects the people more is a federalist system full of checks and balances.
I disagree. While government structure is important to preserving the people's power, Thomas Jefferson was correct. Without a Bill of Rights, strict constructionalist justices like Justice Scalia, Justice Thomas, and Justice Gorsuch may have reasonably held that the Constitution does not bar the government from restricting rights not expressly referenced therein.
There are several advantages to a national Bill of Rights. A federal Bill of Rights creates a uniform standard of rights that states may not infringe upon. Indeed, the Bill of Rights was imperative to advancing the rights of African Americans in states with Jim Crow laws and protecting the people against state laws restricting the rights to abortion, marriage, and voting, as the Supreme Court has held in Roe v. Wade, Obergefell v. Hodges, and Harper v. Virginia State Board of Elections, respectively.
Nevertheless, there are disadvantages to a national Bill of Rights compared to states' bills of rights. First, not all provisions of the United States Bill of Rights apply to the states. Second, state bills of rights often provide greater protections than the federal Bill of Rights. For example, in State v. Henry, the Oregon Supreme Court ruled that Article 1, Section 8 of the Oregon Constitution is broader than the text of the First Amendment, making it difficult for the Oregon legislature to place restrictions on Portland's annual naked bike ride and nude dancing, despite such activities not being protected under the First Amendment.
The U.S. Constitution also differs from state constitutions because it is, as Judge Posner said, a charter of negative rather than positive liberties. Liberty, as defined by John Locke, is a power a man has to do or forbear doing any particular action, or more simply put, the state of being free. Negative rights are the rights to be free from government intrusion. Because the Bill of Rights is primarily a bill of negative rights, the Supreme Court has held that it does not provide protection for housing, education, Medicaid funding for abortion, or protection against violence from a parent.
Conversely, positive rights are rights that require the government to provide its people with goods and services. For example, all 50 state constitutions mandate the creation of an education system, and Article 7, Section 1 of New York's Constitution imposes an affirmative duty on the legislature to aid the needy, as its highest court held in Tucker v. Toya.
Negative rights are more important to the preservation of liberty because they protect citizens from government interference. Historically, when government has wielded power through positive rights, political rights have been limited.
On the other hand, as Isaiah Berlin discussed in Two Concepts of Liberty, a flaw in negative rights theory is that it fails to take into account systemic inequities or sordid political histories, like Jim Crow, slavery, or apartheid, that inevitably have an effect on a person's ability to truly be free. For instance, a child should not be denied an education or housing simply because her parents are poor. While technically that child is not limited by the government from attending school, because of her station in life, she might as well be.
Both my colleagues' arguments are correct. While the preservation of liberty does not guarantee a promise of equality, a balance of both leads not only to the preservation of liberty, but a more just society reflective of the common good. Thank you. We are ready for your follow-up questions.
Very good. Notes away, please. Let me open with the question, what limits can be placed upon individual rights, such as the guarantee of the freedom of speech?
As the Supreme Court ruled in Cox v. New Hampshire, time, place, and manner restrictions may be placed on freedom of expression and speech.
We can see limits be placed on obscenity as held in Miller v. California, and limits on violent speech as the court held in Brandenburg versus Ohio.
However, some state constitutions, as we mentioned in our prepared remarks, provide broader protections for speech. For example, Oregon goes beyond the Supreme Court's ruling in Miller v. California, as the court held in State v. Henry, allowing obscenity, such as naked bike rides or nude dancing, that other states may not allow.
Thank you.
Great. What circumstances, if any, would cause someone to lose rights that are found in the Bill of Rights? I'll give you an example. Should felons have a right to vote? Is there something that we can do as a society that means the government can take away some of the protections we gain under the Bill of Rights?
It differs state to state whether or not felons are granted the negative right to vote we grant within the Constitution. But in Oregon, we do allow this re-enfranchisement after release from being convicted of a felony. And if we establish that not state governments under Article 1, Section 4, Clause 1 of the Constitution could qualify the holding of elections and voting requirements, we could instead establish this to be a federal standard and then establish a federal standard of what felons would have the right to vote. Based underneath that.
Do you think of anything else that can be lost?
You mean, sorry, to clarify, do you mean can be lost as a
consequence? Yeah.
Yes, there are some rights that can be lost. For example, prisoners while in prison don't have a right to freedom of assembly or speech in many cases because they are in their cell. But prisoners also sometimes gain positive rights when they are in the government's care, such as healthcare, because the government, since they're caring for them, has to provide them food, has to provide them healthcare, and some other services as well.
Great, thank you.
What is the difference, if any, between rights added through the amendment process and those established by a court decision?
Rights that are oh, go ahead, Sadie.
Many of the rights that have been established through court decisions are adding on to the rights that we found within the amendments or are unenumerated rights. For example, an unenumerated right that has been established through a court decision is the right to privacy through Griswold v. Connecticut, which use a lot of the rights that have been established through amendments, using the 1st, 3rd, 4th, 5th, 9th, and 14th Amendments respectively. So many of the rights that we've found through court decisions are ones that are unenumerated and are ones that require the usage of other amendments.
Adding on to my colleague, one of the key differences between rights established through the amendment process from Article 5 of the Constitution versus rights established by the Supreme Court or other lower courts is that rights established through the amendment process are more solid and less likely to be taken away. For example, the Supreme Court is looking to change, for example, current religious protections, going from allowing for more religious exemptions from neutral and general laws of general applicability, or under abortion rights, that this current conservative court is looking to take away certain abortion rights. And if that was expressed in amendments, they would not be able to potentially away.
Can states authorize activities as legal within their state that would constitute a federal crime according to federal statutes?
No, they cannot. The federal constitution is the floor, not the ceiling, and so they can grant more protections, but they can't go against the Constitution and grant protections that would be unconstitutional.
I respectfully disagree with my colleague. States actually can provide further protections in terms of criminal rights in terms of state law, because what we're seeing is while marijuana is still federally illegal, we've seen tons of states decriminalize it and legalize it. For example, our home state of Oregon has decriminalized and legalized it for years, and we're starting to see back in November, we've seen more and more states adding to the decriminalization of marijuana.
Another example of state protections in Oregon going beyond federal protections is the right to privacy from police searching or seizing in your own trash. In the Supreme Court held in California v. Greenwood that one does not have a right to privacy and protection from police searching or seizing their garbage, but the Oregon Supreme Court held in Oregon v. Lean that Oregon citizens do under Article 1, Section 9 of the Oregon Constitution.
I'd like to go back to Judge Murphy's question because in your prepared remarks, you might have been split on this particular thing, but I'm remembering a reference to giving judges the power to undermine our rights. So which is this panel more comfortable with, the amendment process at the federal level or the judicial review process when it comes to our rights and freedoms?
When we look at judicial review established in the case Marbury and Madison, it really depends on the type of court that we have at any given time. For example, our current court contains certain originalists and strict constructionists like Justice Thomas, Justice Gorsuch, among others.
Personally, I would reference the judicial interpretation that the Constitution is a living and breathing document to establish new rights. The case that my colleague mentioned, Griswold versus Connecticut, was ruled because it was found that the 9th Amendment can grant unenumerated rights to the people, such as the right to privacy. So viewing the Constitution as something that can change over time due to the station of society is something I view more important than establishing a constitutional amendment.
Adding on to my colleagues' responses, as we've seen, is that the judicial review process is constantly changing, and some may argue it's never constant due to the fact that we always have different courts. For example, the Warren Court obviously was leaning more towards a living, breathing constitution, and right now we have one that's more leaning towards the originalist. And what we know is that judicial review is always going to be kind of an unstable process, but the amendments are pretty steadfast and will continue to be there despite whatever court we may have.
Over time, which has proved more easy to amend, state constitutions or the federal constitution? Oh,
I think
okay.
she held up the sign, but it didn't get it all the way up. So,
All right.
so
I'm sure you would have answered that next question brilliantly, and I will score you accordingly. Number one, I am impressed with the amount of knowledge you have gathered with regard to what is a very, very broad question. And I think that your discussion of these issues was very pertinent and timely. You came with up with a number of developments that are relatively recent. Obviously, the reference to marijuana, the difference between federal, state, and state laws, was very pertinent. And the differences in Oregon, where you've got the state versus Henry on nude dancing and that kind of thing. I thought bringing your current state of law in Oregon was very, very pertinent. The you came up with a reference to Locke and the two treatises on liberty. You called it Concepts of Liberty, and two treatises. You agreed that bills of rights are necessary, and I think that is accurate. But as he pointed out in Hamilton's Federalist 84, he said just because the Constitution doesn't confer a specific right doesn't mean that the people don't have the right, because there's no way we could have listed all the rights of the people, and we've done the best we could in drafting the Constitution. But if it doesn't say you can't do something, that implies that you have the right to do something. That was a very pertinent document in our history. Tucker v. Toya, you came up with some very good cases there. And the limitations on the original question I asked you about hate speech, you came up with obviously obscenity and incitement of violence, as in Brandenburg versus Ohio. You could have mentioned hate speech, as in Chaplinsky versus New Hampshire. You're not allowed to attack another person on the street with what would be deemed to be hate speech. But I thought you made a very pertinent point in that judicial review and rights created by the courts, as opposed to amendments and or state or federal legislatures, can be somewhat fluid depending upon the orientation of the judges, the 9 judges on the court. And I thought that was a very pertinent comment. But I enjoyed, you did get into penumbral rights, the unenumerated rights with Griswold. You could have cited a great many others like Leving versus Virginia on interracial marriage and those kinds of things. Under the Equal Protection Clause, there probably is not a more important amendment than the 14th Amendment, which allowed for incorporation of the Bill of Rights as applicable to the states. I would have enjoyed a conversation about that, but nonetheless, I know you have only 4 minutes and then 8 minutes in the question and answer session. But you demonstrated very significant knowledge, and I applaud you for what you have done. I applaud your teachers and your coaches for what they have led you to in terms of your knowledge. I'll turn the rest of the comments over to my colleagues.
I totally agree. That was an excellent preparation. You all did very well. I liked everything you were able to pack into your prepared remarks, but you didn't jam everything in that you were going so fast and that you were disrupting the cadence. I was actually able to follow along with all the points you were bringing to bear. You took a good starter question from Judge Volpe, and yes, you gave us the definitional answer, and then I think Ben, it was you that then took the opportunity to say, okay, well, some states will give broader rights, right? And you kind of pivoted a little bit to demonstrate something else that you knew that was relevant to the topic, but not exactly asked. I thought that was really smart. I probably confused you a little bit with the question I started with, and then I baited you with an example that wasn't directly in the Bill of Rights, but I forget if it was Sadie or Madison who worked it in nonetheless. I was trying to get at rights of incarcerated and formerly incarcerated persons. And hear you talk about that a little bit, which we got around to. I liked the comment, you know, prisoners lose rights of assembly, but they gain positive rights, like the state's duty to look after their health care. So I thought that was a really great answer to my question. And my only other piece of maybe constructive feedback is I asked you an opinion question at the end, and those are always tricky because you want to use them to show us what you know, but I also want to hear opinions. And Madison, I think you came with one. But if a judge gives you a little bit of a freebie, just consider weighing that, you know, taking a position, but also showing us what you know. That'll make your answer that much stronger. But you did an excellent job. I really had fun talking with you today.
I don't really have a lot to add beyond what my fellow judges have said. They've covered a lot, but I did enjoy the back and forth, the not a uniformity in your decisions or your consensus opinions about these different topics. This is a very broad area, and there's a lot of opportunities for you to give opinions and thoughts about not specifically individual cases, but a little bit broader areas. And I think you were able to do that in some of the circumstances. So feel free to be able to elaborate a little bit more on how you personally feel about it, in addition to talking about the cases and that sort of thing. But very well done. I enjoyed the presentation, and thank you.
Thank you.